Earlier this afternoon, I had the opportunity, the honor, to chair a hearing of the Senate Judiciary Committee on which we serve, to consider the President's nomination of a highly qualified lawyer, Sri Srinivasan, to serve on the D.C. Circuit Court of Appeals. And I'm encouraged by what the Majority Leader has just said about the very real possibility we will get a vote on the floor of this Senate on vital and important issues affecting guns, immigration, and other issues. But what I speak to today is the absolutely essential role that this Senate must fill of voting on qualified judges who've been nominated to the circuit courts of the United States. Earlier today in this hearing, 10 of our colleagues, Republicans and Democrats, asked thoughtful questions, and Mr. Srinivasan gave thorough and thoughtful answers. I came away convinced that he has the background, the education, the skills, and most importantly, the temperament to serve as a circuit court judge. And I was encouraged by comments of my colleagues, both Republican and Democrat, that they too were inclined to support this nomination. Under normal, historical circumstances, today's hearing would be the beginning of a deliberate, timely, orderly process, a process required of this body by Article 2, Section 2 of our Constitution, by which we advise and consent to the President's nominations. We should, of course, carefully consider the qualifications of candidates and not serve as some rubber stamp. But neither should we be a firewall, blocking qualified nominees from service. And unfortunately, for some number of years, this Senate has in some vital instances served more as firewall than as advice and consent body. Instead of doing our due diligence with appropriate speed, we've seen delays, stalling tactics, and in some instances, sadly, filibusters of highly qualified nominees. 5 years into President Obama's administration, the courts are still nearly 10% vacant. In my view, our courts should be above politics, and when the president of either party submits a highly qualified candidate of good character and sound legal mind, absent exceptional circumstances, that candidate's entitled to a vote. The actions, or in this case, inaction of the Senate with regards to the D.C. Circuit have consequences. The D.C. Circuit Court of Appeals has a series of vacancies, the result of which, in my view, are delayed and denied justice for Americans far beyond the boundaries of this District of Columbia. The D.C. Circuit Court is often called the second most important in the nation because, like the Supreme Court, it handles cases that impact Americans all over our country. It regularly hears cases on issues ranging from terrorism and detention to the scope of federal agency power, and yet it is critically understaffed. This circuit court hasn't seen a nominee confirmed since President George W. Bush's fourth nominee to that court was confirmed in 2006. Today, more than 1,500 days after President Obama has taken office, 4 of the 11 seats on the D.C. Circuit are open, making it more than a third vacant and putting the remaining judges under undue strain to decide the complex and important cases before this court. Contrary to the previous administration, this administration was recently recognized by the New York Times editorial board as putting forward nominees who are decidedly moderate. President Obama first nominated for this vacancy on this court the exceptionally qualified Caitlin Halligan, who waited more than 900 days for a simple up or down vote on the floor of this chamber. She came with the American Bar Association's highest rating, glowing recommendations from bipartisan supporters, and a diverse legal career marked by distinctive service as New York Solicitor General. Nevertheless, sadly here, Republican senators successfully filibustered her nomination, and last month, President Obama reluctantly withdrew Ms. Halligan from consideration. We have today a chance for a fresh start with Mr. Srinivasan, who would serve equally well and ably on the D.C. Circuit Court of Appeals. As he demonstrated in today's hearing, he has a sharp and capable legal mind. He served in the Solicitor General's office for both Republican and Democratic administrations. He has served in the private sector and the public sector and has earned bipartisan support from those who have worked with him. In fact, he's been endorsed publicly in a letter from 12 former Solicitors General and Principal Deputy Solicitors General, 6 Democrats, 6 Republicans, or those who've served in Democratic and Republican administrations. The letter, signed by conservative legal luminaries such as Paul Clement and Ted Olson, notes Mr. Srinivasan is one of the best appellate lawyers in the country, with an unsurpassed work ethic, who is, quote, extremely well prepared to take on the intellectual rigors of serving as a D.C. Circuit Court judge. At the same time, throughout the course of his career in private practice and as a public servant, He's represented clients with causes diverse enough that any individual policymaker or elected official is likely to disagree with some of them, including me. I disagree with the position he argued in Rumsfeld versus Padilla in support of the idea that the government has a right to detain U.S. citizens indefinitely. But I don't ascribe that position to him. One of the most foundational principles of our legal system is that you do not ascribe to the attorney the position which he successfully and vigorously advocates on behalf of his client. I will not block his nomination simply because I might disagree with the position he took on behalf of a client in one case. Sri, in my view, is a highly capable attorney with the character and demeanor to serve on the bench, and I will strongly support his nomination. I am following, in this instance, the wisdom of Chief Justice Roberts, who has said, and I quote, "It's a tradition of the American bar that goes back before the founding of our nation, that lawyers are not identified with the positions of their clients," close quote. So I say to my colleagues here, let's move forward in that spirit. Let's return to our historic, constitutionally mandated role. Let's give Mr. Srinivasan a speedy up or down vote, which I believe he's earned, with decades of public service and private sector experience. To be honest, Mr. President, if this nomination cannot move forward, if this nomination is filibustered for what really can only be political reasons, I can't imagine what nomination could move forward to this court. A filibuster of this nominee would sadly prove to me, just as it did to those of the other party in 2005, that the judicial nomination standards and procedures at work here are unworkable, the system broken, and it would lead to a reconsideration. There was a crisis just of this sort when the parties were of opposite configuration in 2005 that led the majority to threaten the so-called nuclear option to end judicial filibusters by the party in which I serve. A result that was avoided only at the last moment for the good of the Senate and the nation. I urge my colleagues to come together to give this good man a vote and avoid another such crisis today. Let's do our job so that the judges of the D.C. Circuit Court of Appeals can do theirs for the people of our nation.